Hello everybody. Today I'm going to explain the single worst count in the entire YSL trial, count 52 against Shannon Stillwell. And we're going to start with a little clip here that some people couldn't hear or understand completely, and then I'm going to explain exactly what happened and why it was terrible. So, here we go.
0.00.
Your Honor, we do. Yes, we do, Your Honor.
We need it tailored to 133, right?
No, unfortunately, no, Your Honor. When we, in looking at the indictment, Your Honor, it looks like for count for the two counts, count 63 and count 52. While we did charge 133,
Yeah.
it is missing an element. And
It's missing the indictment is missing an element.
yes, Your Honor.
That was going to be subject to the motion.
And so we believe that the language as charged is a 131 charge and
So-
not a 132.
What's it missing?
It's missing the crime that they committed while being in possession of the handgun.
So I don't think y'all get a do-over on that right now.
But we believe that the evidence that's established has the elements
I
of
think it
131.
probably has potentially, but you charged 133. So if you get a do-over to do 106 or whatever it is, then you need to give me law that establishes that.
Okay, we'll get you along.
Okay, so as you might expect, there are two laws at issue here that were confused. Actually, no, before I say that, I want to say one thing. It actually was not just counts 52 and 63. It was also count 30, 64, 65, but details, you know? So in any event, this is 16-11-133. This is the count that, if you look at the re-indictment, this is what it charges, 16-11-133. Oh, didn't mean to do that. And so, first I'm going to show you the statute, 16-11-133. There are a few different things that you have to allege this crime. This is the first one here. Previously been convicted of basically certain felonies. Just think of it as you have to have been convicted of a felony. And then the next thing is you have on or within arm's reach of your person. Basically, you physically have a firearm during the commission of, just think of it as another felony. So you have one convicted felon. You have so this is what you have to have, what you have to allege to prove. Ooh, that's big. But nonetheless, this is what you have to have. Prove 133. You have a convicted felon that had a gun during the commission of a felony. Now, turning to 131. Actually, no, let's take a look at the re-indictment first. This is 16-11-133. Let's see if I can make this a better size for you. There we go. So, let's see what we have here. We have did possess a firearm. That's actually not good enough. Possess does not necessarily mean that it's on your person. You can possess a firearm if it's, say you're a driver and it's in the glove compartment. You have a gun in the glove compartment of your car. That can be possession, even though it's not on your person or within arm's reach, unless you have really long arms. But that counts as possession. So possession is a looser standard than on your person. So this part is actually insufficient. But they say a firearm, that's fine. They say after having been convicted of felonies, that's also fine. But then you'll see that there's no language here about the felony. This is what Ms. Hilton was referencing when she said there's no allegation of the crime that was being committed while Mr. Stillwell had the firearm. I'll show you that part again so you can hear exactly what she says.
For the two counts, count 63 and count 52, while we did charge 133,
Yeah.
it is missing an element. And
It's missing the indictment is missing an element.
Yes, Your Honor.
That was going to be subject to motion.
And so we believe that the language as charged is a 131 charge and
So-
not a 133.
What's it missing?
It's missing the crime that they committed while being in possession of the handgun.
So I don't think y'all get.
Okay, so this is the part that we were just discussing here. There's no language about what felony was being committed while Mr. Stillwell had the gun, or Mr. Kendrick, or Mr. Sledge, or Mr. Nichols, I think, was the other one. And so if you go, Ms. Hilton says 131 is what they charged, and that's probably correct. This is a very similar charge. It is basically 133 with a couple of changes. You need to have a person who has been convicted of a felony, who receives, possesses, or transports a firearm. That's it. It is just convicted felon in possession of a firearm. And one important thing is you'll see that the penalty is a lot less severe. It's basically up to 10 years. It can be just 5 years. It depends on the circumstances. I'm not going to get into the details of it. It's actually really strange. But 133 is a mandatory 15 years. It can be probated, but it is exactly 15 years. It is not 1 to 15. And more importantly, it is run consecutively, meaning one after another. So in this case, say you have the RICO, that's 1 to 20 years, or 5 to 20 years, and then 133. That means it would be a minimum of 20 years if you're convicted of both, the 5 and then the consecutive 15. Whereas if you have 133, you could have 5 years for the RICO and 5 years for the 131 concurrently, and that would be a total of 5 years. So you're looking at a 15-year increase, potentially, between 131 and 133. Going from 5 years to 20 years, just because of that one mistake. So it's a significant increase in the punishment, going from 131 to 133. So it is a major change. Now, the reason that this is the worst one, as opposed, like count 52 is the worst count, as opposed to count 63, is that if you go to the original indictment, this is the original indictment here. This is the re-indictment. So this is the amended version, this is the original version. And if you know nothing at all about the law, you can still look at these two and just say, originally there seems to be more stuff here. And then in the re-indictment, there's less stuff. There are fewer words. Original or amended version. So they took stuff out in the later version. So let's look at the original. And this is not the version that Ms. Hilton was talking about. This is the original version. It was only effective from May 9th, 2022 until August 5th of 22. And then this version became the effective version. So this version is the one that was in effect the entire trial. But this is the original. So let's see what it says. We have, see, it still charges 133. But the language you'll see is different. It says possess or have within arm's reach of his person. Now that's still not right, but it's almost right. If you get rid of this part, it would be correct. But it's almost right. Then they have a firearm, which is correct, during the commission of a crime against or involving the person of another, to wit, the murder of Shamel Drinks. So this is correct. But the interesting thing is they took that stuff out in the later version. It's the exact same count, but for some reason, they deleted the to wit, the attempted murder of Shamel Drinks, and they took out within arm's reach. See here? Oh. This part was deleted, and this part, all the underlined parts were deleted. This was all deleted, everything that was underlined. They also took out this part. Oh, not this part. This part here. So, that is why I think that this is the worst count in the entire case, is because not only is it wrong, but it was slightly wrong in the original indictment, but then they made it worse, seemingly intentionally, in the re-indictment. And I have two I want to show you. This is Mr. Stillwell's, you can see that okay. So this is Mr. Stillwell's final disposition, his written sentence. You go down here, we have count 52 right here. And you'll see here, this is the directed verdict of acquittal as to 1611-133. But then Judge Whitaker, and this was reasonable, allowed the state to try to, they charged him with 131, which is the lesser included offense. And they also lost on this one. So they actually took 2 losses on 1 count. So these are both losses, and it's not just that they lost twice on 1 count, it's that they had it almost right and then they made it worse. There's one more thing I want to show you. This was the runner-up, is count 63. It's the same issue. This is for Mr. Deamonte Kendrick, aka Yak Gotti. And you'll see here count 63. Same thing, formatted a little differently. Got the directed verdict on 133 and got acquitted on 131. Now this is my favorite part. If you count the counts, you see you have 1, 2, 3, 4, 5, 6, 7. Whoa. Eight, 9, 10. 1, 2, 3, 4, 5, 6, 7, 8, 9. Yeah, that's what I thought. There are 9 counts. But then if you count up the losses, you have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. So they actually had 10 losses in just 9 counts against Mr. Kendrick. And if you do the math, that's actually a 111.1, repeating, of course, % loss rate. So if you say that the state lost 100% of its case against Deamonte Kendrick, you'd actually be giving them too much credit, which I find remarkable. They more than 100% lost their case. Remarkable performance all the way around. But yes, that is why I think count 52 is still worse, because it was broken like halfway through the case for no apparent reason. I mean, I do know why they did it. I'm not going to get into that, but this was correct-ish, almost correct. It was Fulton County correct, and then it was made incorrect. So I think count 52 edges out count 63, even though it's the same issue, because count 63 was only included in the reindictment, so it wasn't broken halfway through. But then again, with Kendrick, you have the full body of work and the 111.1% loss rate. So, reasonable people can disagree as to which one's more embarrassing. I'm kind of talking myself into this one, to be honest with you, but either way, you can't go wrong. And yeah, so that is what happened with the 133 counts. And like I said, it wasn't just counts 52 and 63. I'll show you that real quick. It was count 30. This one has the mistake. It was counts 52 and 53. 52, this is the one we talked about. And 53, Quay Marvis Nichols, 133 here as well. It was, I think, 62 to 65, if I'm not mistaken. 63 to 65. 133 here, 133 here, and 133 here. And those were all incorrect. And remember what I said about the sentencing on 133 versus 131. You're looking at a difference, significant penalty difference between the two crimes. Significant difference. So that is 133, 131, Deamonte Kendrick, Shannon Stillwell, 52, 30, 52, 63, 64, 65. And yeah, this is episode 2, and I will find another topic to do soon. But thanks for watching.